And welcome back, everyone. Attorney Craig Steger here. Another day, another live stream. Today, I want to talk about sidewalks and icy sidewalks, something very common here in the Midwest and even common now in the South, who is getting hit with historic snow and ice and all that kind of stuff. I took a picture outside my office a few days ago that I think will be very helpful in helping you understand, at least in Wisconsin, how the rules work when it comes to slip and fall injuries on sidewalks. But before we get started there, let's get this out of the way. Just a reminder that this live stream is for informational purposes only and does not constitute legal advice. Viewing or participating in this live stream does not create an attorney-client relationship. So I'm going to do my best to kind of answer some general ideas and questions relating to sidewalks and ice and falls and who's responsible. But one thing I will emphasize is this. In particular, icy sidewalks are, I would say, very fact-intensive and can be very nuanced for a number of reasons and can vary a lot by state, okay? To make things simpler, I'm going to specifically refer to Wisconsin, where I live and my offices are at, and where I do most of my work. I think a lot of the things I talk about here will more or less be true in other states such as Iowa and Minnesota, but there will definitely be some differences, especially as it pertains to municipal liability, municipal immunity, and things like that. If you have any questions or anything during the live stream, feel free to add them to the chat. I'll do my best to answer them if I can. Sometimes I need to think about it or look something up, and I'll do it in another video. If you have a particular legal question, let's say you or someone you know actually slipped and got hurt on icy sidewalk, don't leave that stuff in the chat or the comments. It's best to reach out to an attorney directly and talk to them about that so that those discussions are confidential. If you'd like to reach out to me, just go to the description below. My contact information is there. So I want to start by showing a picture. And when I came to the office last week, I saw this and I had to take a picture of it because I thought, well, this is a very useful photograph. So let me put it on the screen here. And maybe I'll just leave myself on the side here. So this is right outside the door. Actually, so it's like right outside from where I am right now. The main entrance to the office is just over here out of sight on the right. Our office is space that we rent from the owner of this property, which is actually attached to the bank in town. So they're the owners of the property. This is a new construction, which is one of the reasons I wanted to take this picture, because a lot of times it can be important to know who owns the property and how long they've owned it, especially if let's say the snow or ice or whatever is because of a downspout placement or low spots and things like that. The age of it can be important because we have things called statutes of repose in Wisconsin that can prevent otherwise meritorious claims. This is all new construction within the last few years, so that would not apply. The statute of repose wouldn't apply here. But so here's what I noticed. I came in, and I don't have a photograph, but directly above it is I don't know if it's not a downspout, but something with the gutters and the roof line. It was starting to leak there. Not entirely sure why. It shouldn't be leaking there at all, but it was leaking water from the roof down onto the sidewalk, and it was creating ice. And so the property owner had put salt out there and actually went so far as to put an orange cone there, which is nice, but interesting for a couple of reasons. So and this kind of concept also applies in, let's say, grocery stores and department stores where you may have liquid on the floor. When owners put up signs, it's a sort of a two-edged sword for them, because on the one hand, it's there to warn people of a hazard. But the other side of that is it shows that the owner clearly was aware of the problem, and so they went ahead and warned about it. And so once a cone is out there, it's much more difficult for a property owner to say, well, hey, we didn't know there was ice there, which is oftentimes a defense in most, let's say, sidewalk slip and falls as well. We didn't know there was a problem. We don't have people out in the parking lot 24/7 watching for icy spots to form. And so claiming a lack of knowledge is often an important defense in the defense of slip and falls. Well, here there's no real dispute that the owner knew about it. And you could see where they had salted it and had put a cone there. Clearly, they're aware of, well, they were aware of the sort of the slippery conditions that day, but I think arguably are aware of whatever it is going on above them on the roof line, which could be important in the future if they don't, have someone come out and make some repairs or adjustments to that. So the fact that there was a cone there in particular caught my attention because, thank you. I mean, thank you for doing the right thing. But for property owners, like I said, that can be sort of a two-edged sword. If they, you know, if someone should eventually fall anyway, then it's going to be really hard for them to claim they didn't know that the problem existed. Maybe they needed to take more drastic measures. Maybe they needed to add more salt, put something to stop water from leaking on the roof down onto the sidewalk, different things. But one of the things that's interesting, I find fascinating in Wisconsin, at least, and I think this is different from how it works in, let's say, other states, is in Wisconsin, at least, generally speaking, sidewalks are going to be owned by the municipality. That could be the city, village, town, whatever. If they're alongside the street, even if there is like a green, I think it's called a boulevard, but you'll have the street to the curb, and then there's usually sort of a grassy path. Oftentimes there'll be trees planted in that, and then the sidewalk. Typically in Wisconsin, at least, that sidewalk, the entire sidewalk, is actually owned by the municipality. However, in most municipalities, there'll be an ordinance that requires the property owner, the adjacent property owner, in fact, to salt and maintain and push snow and things like that, even though the property owner doesn't actually own the sidewalk. At least that's typically how it works. And so what's important about that is what that means is, as a general proposition. Now, this could be true if it's a slippery sidewalk in the winter, or maybe there are large cracks in the sidewalk over time, those kinds of things. If the city or the village, in this case, we're in a village here, owns that sidewalk, even if the adjacent property owner is required by ordinance to maintain that, there probably isn't a claim against the private property owner or the business. The claim would be against the municipality that actually owns it, and you can't necessarily delegate that. And so that's something to keep in mind, and it can be important. And sometimes, now, like here, if you look at this picture here, you see the cracks on the line. I'm not entirely sure if any of the sidewalk here is actually owned by the village, or if it's all owned by the property owner, or maybe part of it is. So depending on where someone falls, it can make a big difference. And so it's really important, if someone does fall, on a, let's see, an icy patch on the sidewalk, you take a lot of pictures right away, and pictures from different angles and far enough away so that you can sort of orient yourself to where it happened, in case there becomes a question later on about whether this was on the private property owner's side of the sidewalk or whatever, or if it in fact was on the public sidewalk. Something, so it's really, really helpful to have pictures if someone falls of exactly where they fell, close up, far away, different angles, whatever is needed, so that you can later establish exactly where someone fell. But one of the really important things you're going to want to find out right away is who actually owns the spot where someone fell. In this case, what's interesting is this isn't natural accumulation. This is really unnatural accumulations, because it's coming from water that is coming off the roof and landing on the sidewalk below, as opposed to, you know, rain or precipitation in this spot. That can, depending on the circumstances, lead to a claim against the property owner, who may, in theory, have a claim against the whoever did the construction on this, if they think it was done improperly. One of the important things in Wisconsin, at least, and I'm not entirely sure off the top of my head what the rules are in, let's say, Wisconsin and Minnesota, but one of the important things about sidewalks and parking lots and things like that in Wisconsin is that if they're owned by the municipality, there's going to be a few important rules that are going to apply. I pulled out my statute book here. I've got an old set here, but the rules haven't really changed. But so in Wisconsin statute 893.83 deals specifically with liability from accumulation of snow or ice, and that deals with cities, villages, towns, and counties. And it says no action may be maintained against a city, village, town, or county to recover damages for injuries sustained by reason of an accumulation of snow or ice upon any bridge or highway, unless the accumulation existed for 3 weeks. So that's kind of interesting. I believe that highway is defined broadly and isn't just, let's say, highways, includes streets, includes public parking lots, and I believe in Wisconsin includes public sidewalks. They are considered part of the highway, even though we don't really refer to them as highways, we refer to them as sidewalks. And most importantly, the accumulation has to exist for 3 weeks. I know that this didn't exist for 3 weeks because I had been there the day before. So this was a recent event. And if the village owns this entire chunk of the sidewalk and someone slipped and fell on it, it's probably unlikely that the village is actually going to be legally liable. The other thing to keep in mind when it comes to municipalities is we have special notice rules in Wisconsin, which require if an injury happens, you have to provide written notice of circumstances on a city, town, county, state. There's a different rule for the state versus all other municipalities, but the deadline is basically the same, which is 120 days from the date of the injury or whatever. A written notice of circumstances. Basically, it provides a summary of what happened to put the municipality on notice that, oh, by the way, there may be a claim coming in against you, and that gives them time to go out and document it, photograph it, maybe talk to witnesses, things like that. And then later on, there's a requirement to actually submit a written demand on the municipality and give them a certain period of time to respond to that before you can file a lawsuit. But this 120-day deadline to provide notice is really important, and most people are not aware of it. And so that's why in cases of slip and falls, it's really important to talk to an attorney right away, so that if it's necessary to at least preserve that right, even if you're not entirely sure you're going to take legal action, it's important to serve that notice of circumstances in time so that that claim is preserved. That's pretty unique to Wisconsin. I don't believe that Iowa, and I'm not sure about Minnesota, have similar rules for municipal liability and providing notice of circumstances, but it's a very, very important feature in Wisconsin, at least. So, I don't think there's anything else I wanted to show about this picture, but yeah, you can see exactly where it's at. The cone maybe wasn't all that necessary, but it does help draw attention to it. And I wouldn't be surprised if this property owner has someone out coming to look at and possibly fix this gutter or whatever was malfunctioning here as soon as possible. But that would be, some of the information you want to try and get it right away is and something like this is actually look up and take pictures of where it's dripping from. Try and get some pictures from different angles, maybe some video. You want to try and get images exactly where it is coming from. Document the day that it was taken, the time, because you can use weather data records later on to try and figure out when it was the last precipitation event. Comparative fault is always something to keep in mind. So we are required, generally speaking, to exercise reasonable control ourselves. Supposed to be paying attention. Let's say someone is walking through this area and they're on their phone, so they don't even see the cone. They slip and fall. That can be comparative fault against the injured person. And if that comparative fault is more than, let's say, 50% of the liability, they may get nothing. That's called comparative fault. One thing I wanted to mention, I already kind of talked about a little bit, is the statute of repose. What is a statute of repose? So statute of limitations is a legal deadline to take action that is typically based on when an injury happens. And that starts the clock running. In Wisconsin, for example, it's typically 3 years from the date of an injury to file a lawsuit and bring legal action. That's a statute of limitations. A statute of repose is a little similar, but it actually works kind of in the opposite direction. Some people refer to this as being grandfathered in, but it sort of is. If a property has existed long enough in a defective defective way, I'm not even sure what it is, 10, 15 years, something like that. If this side, let's say this downspout has been leaking water on the sidewalk for 30 years and no one has ever bothered to do anything about it, that claim, even if it's clear that the downspout is defective, may be dismissed right away in the lawsuit on what we call statute of repose grounds, which basically says, listen, we're only going to allow you to go back so far. Owners change hands, things like that. And so statute of repose kind of puts a backward-looking limit on how far you can go back and hold someone liable. Sorry, tired today, guys. Let's see. Some other things that might be relevant. How long has it been since it snowed? How often do they go out and shovel and put salt on it? Those are really important things to figure out. Take photos, video, anything like that. Obviously, go to the doctor right away if someone slips and is, falls and potentially injured. Do it as a precautionary matter. I think what else? I think that's kind of what I wanted to talk about today. So I thought that picture was I thought it was a really good picture, and it helps kind of highlight some of the issues that are important when it comes to slip and falls, at least here in the Midwest. Let's see, I'll take that back down. People have questions about slip and fall liability. Slip and falls tend to be, what do I say? more difficult to pursue and win than, let's say, an auto accident or something like that, or even a trip and fall, because trip and falls involve, uneven stairs, uneven sidewalk pieces, or whatever, can give rise to liability because it's existed for a while. Here in the Midwest, we know it snows, we know it rains, we know things melt, and so a certain amount of snow and ice is kind of just part of the reality of living in the Midwest, and so property owners aren't required to, be out there 24/7, constantly monitoring. They tend to have duty of reasonable care. You do need to take reasonable exercise to clear snow, salt the ice, things like that. And if you can't do it, to hire someone that can do it. So that duty of reasonable care is important. Knowing who owns the property, especially if you're talking about sidewalks, parking lots, streets, things like that. Know if it's a municipality, and realize that there may be a short window to provide them with written notice. Otherwise, they can try to avoid liability later on if that notice isn't provided. That's especially true when you're talking about the state. The state is, if you're going to sue the state, the courts tend to enforce that 120-day notice thing much more rigidly and rigorously than, let's say, claims against other municipalities, cities, towns, villages, things like that. Yeah, I hope that's helpful. It's a kind of a good time of year to talk about this, since we're right in the middle of winter here and things do get icy. So be careful out there. Take your time. Document things, take pictures, video, things like that. If there is an incident that clearly shows where someone fell, so that if there is a claim to be brought later on, you can establish as good as possible exactly where someone slipped and hurt themselves. So that's all I wanted to talk about today. Appreciate you watching my video. I would appreciate it if you find value here to hit subscribe and like the videos. If you have a question or comment, feel free to leave it below. If you have a specific legal question, don't put it in the comment section. Just go down to the description and send me a message, give me a call, whatever is easiest for you. So with that, I'm gonna wrap it up. Appreciate everyone for watching, and until next time, everyone, have a good one.